Chances are, if you clicked on this video, you're either a social media content creator, an outdoor national parks enthusiast, or perhaps both. You might even have an inkling about what has recently occurred in regard to the enhanced videography restrictions on our public lands. Yes, these enhanced restrictions apply not only to our national parks, but to all of our federally managed public lands. National forests, deserts, monuments, historic sites, it's an extensive list. Let's dive into this debacle. In 2018, a gentleman named Gordon Prince and a few of his cohorts decided to create a documentary about paranormal activity in and around the site of a Civil War battlefield. This site is administered by the National Park Service. Prince, unbeknownst to the NPS, filmed portions of the documentary at the battlefield site and went on to produce the video, which gained some notoriety. At some point, the NPS became aware of the battlefield content and decided to criminally cite Prince for his videography on an NPS site without first obtaining a permit. Prince challenged the First Amendment legality of the NPS permitting requirement, which resulted in NPS rescinding the citation and essentially dropping the matter. Prince then decided to sue the NPS for violation of his First Amendment rights. The suit was filed in and heard by the U.S. District Court for the District of Columbia. The court agreed with the premise of the suit and struck down the permitting requirement. The NPS then appealed the case to the Federal D.C. Court of Appeals, where a three-judge panel divided 2-1 in finding for the NPS. Subsequent to this finding, a now emboldened NPS updated and enhanced their videography permitting requirements, as did the other Department of Interior and Department of Agricultural public land management agencies. Shortly thereafter, the NPS website question and answer page regarding filming and required permits was updated to read as follows. Federal law requires a permit for all commercial filming, no matter the size of the crew or the type of equipment. This includes individuals or small groups that don't use much equipment but generate revenue by posting footage on websites such as YouTube and TikTok. Take note of that reference, such as YouTube and TikTok. That infers a permit is required for video posting to any and all social media platforms, whether it be Facebook, Instagram, Twitter, LinkedIn. But you say, I don't generate any income from my posts. Oh, but the platform does through ad revenue. If you post video to social media, you, my friend, are a commercial videographer in the eyes of the federal government. So is this the death of all those outdoor channel content creators? Family summer vacation videos? Those weekend getaway posts? Well, it's complicated. The D.C. Circuit Court has given the following opinions. Judge Ginsburg, who wrote the majority opinion, cited the following as a basis for their reversal of the lower court. Though protected as speech under the First Amendment, filmmaking, like typing a manuscript, is not itself a communicative activity. It is merely a step in the creation of speech that will be communicated at some other time, usually in some other location. Creation of speech is not the type of activity for which streets and parks have been used, time out of mind, and therefore it cannot be said that they have immorally been held in trust for such activity. There is no historical right of access to government property in order to create speech. Judge Henderson wrote the concurring opinion. Although I'm in complete agreement with Judge Ginsburg's analysis and joined it fully, I write separately only to emphasize the limited reach of the court's holding. We conclude that the regulation of most non-communicative speech on government property is subject to reasonableness review. We did not and do not explain the full contours of what does and does not constitute communicative speech. Under Supreme Court precedent, communicative speech is that which intends to convey a particularized message in a manner that allows others to understand it. After today, we will still apply heightened security to a wide variety of speech. Price's filmmaking presents a paradigmatic example of non-communicative speech, which is itself an oxymoronic term. As Judge Ginsburg explains, it is merely a step in the creation of speech. Indeed, Price will still need to edit and show his film before communicating what he intends to convey. Judge Tatel, the lone dissenter, wrote the following opinion. Even though our court recently struck down similar restrictions on speech in national parks as overbroad and antithetical to core First Amendment principles, the court today upholds these restrictions on grounds untethered from our court's precedent and that of our sister circuits. because the permit and fee requirements penalize far more speech than necessary to advance the government-asserted interests, they run afoul of the First Amendment. But there's a wrinkle in the D.C. Circuit Court's majority opinion that the government is using to institute and enforce the videography permitting laws. With the exception of the U.S. Supreme Court, federal circuit courts of appeals do not bind other circuit courts or lower courts outside the circuit in which they are located. That is, a federal Supreme Court decision is binding on all lower federal courts, both circuit courts of appeals and district courts. However, a federal circuit decision is only binding on all federal courts within its circuit, but not federal appellate or district courts in other circuits. For example, a decision of the U.S. Court of Appeals for the Ninth Circuit binds the U.S. district courts within the Ninth Circuit, but not federal appellate or district courts in any other circuit. Thus, the D.C. Circuit opinion in this case, upon which the Department of Interior, which includes the National Park Service, BLM, Fish and Wildlife, and the Department of Agriculture, U.S. Forest Service, are using to substantiate the legality of their First Amendment position requiring filming permits, is presently only valid and upheld within the jurisdictional boundaries of the D.C. Circuit. It is permissible for other federal appellate courts to concur with the D.C. Circuit opinion, but those circuits are equally permitted to disagree. In addition to the D.C. Circuit, there are 11 other federal circuit courts of appeals, commonly referred to simply as circuits. The largest by geographic area, population, and number of judges is the Ninth Circuit. It's comprised of 9 western states: Hawaii, Alaska, Washington, Oregon, California, Idaho, Montana, Nevada, and Arizona. The vast majority of federally administered public lands are located in the Ninth Circuit. And here's the kicker. The Ninth Circuit has taken a completely opposite position on how the First Amendment applies to and protects the public's right to capture videography images on public lands. In a very recent Ninth Circuit appellate case, the majority opinion stated the following: there is a First Amendment right to film matters of public interest. The act of recording is itself an inherently expressive activity protected by the First Amendment. We reason that the audio and video recordings require decisions about content, composition, and the like, which decisions are just as expressive as the written word or a musical score, ultimately disseminated to the public. Because the recording process is itself expressive and is inextricably intertwined with the resulting recording, the creation of audiovisual recordings is speech entitled to First Amendment protection as purely expressive activity. So there you have it. The circuits are split. It can only be decided ultimately by the Supreme Court, which presently has declined to review and hear this issue. So the question remains: is it legal to video on public lands without a permit? I'm of the opinion that capturing video on public lands, at least within the jurisdictional boundaries of the Ninth Circuit, even with the intent to post to social media, can legally be done. However, having said that, I'm not an attorney, and this is not legal advice. I also suspect that somebody doing so is at risk, at least partially, of becoming a Department of Interior or Department of Agricultural test case. I guess we'll have to decide if the rewards are worth the risk and potential litigation on our own. Best of luck to all you videographers out there. I hope someday our paths cross. Take care until then. I'm out.